In terms of Section 60, subsection 4A, the court found that the applicant, if released on bail, will endanger the public safety, taking into consideration the degree of violence that was used during the commission of the offense. The prevalence of such offenses have been an epidemic in our society, that the applicant acted as a group in the commission of this offense. They lighted against the defenseless person and firearm was used in the commission of the offense. There is a likelihood that applicant, should he be released on bail, he will evade the trial. He does not have a fixed address because of he submitted different addresses, and therefore it may be difficult for the state to trace him. I also take into consideration the strength of the case and the severity of punishment to be meted out if the accused is found guilty. There is likelihood that he will interfere with the witnesses. The applicant know who are the witnesses of this case. The investigating officer emphasized the safety of the witnesses and said that the safety of the witnesses are at stake. There is likelihood that he will jeopardize the functioning of criminal justice, as there are outstanding suspects and he may interfere with the investigation. And that should the applicant be released, there is a likelihood he will disturb the public order or public peace. This incident occurred in the public domain, and community need to be protected from such violence. And as such, the applicant cannot be released back to the same society that he have offended. This will lead to public to lose confidence in the justice system. The fact that the applicant says he intending to raise an alibi as a defense does not automatically convert his circumstances to be exceptional. The issues involving cautionary rule relating to single witnesses, identity, ID parade flaws, and the issue of video footage are all issues that need to be determined at the trial court and have to be weighed up beyond reasonable doubt at that stage. And this court will not make any credible finding of all issues, as I have mentioned. I will leave them for the trial court. State versus Mazibuko and the others, it was held that for the circumstances to qualify as sufficiently exceptional to justify the accused release on bail, it must be one way exceptionally heavy in favor of the accused, there rendering the case for his release on bail exceptionally strong or compelling. Therefore, the court found that there are no exceptional circumstances which, in the interest of justice, may permit his release. Therefore, his bail is denied.
Lordship will request that this matter be postponed to the 11th of February back to the trial court.
Is it sufficient, Mr.
Just for to enable us to take further instructions on this matter and on the judgment. Lordship, stop this.
How about the 26th February for further investigations?
Our postponement has got nothing to do with further investigations. The 11th is more than enough time for us to obtain instructions. If there are outstanding investigations, obviously we know, the matter will be postponed by the trial court for that purpose. It's in March. That's what I'm doing.
Mr. Majola, please stand up. Case postponed to the 11th of February for investigation. You are in custody. You will appear in court number 23.
Lordship.
Yes.
Understood.